Good afternoon. My name is Twyla Tardif, and I am the director of the Lieberthal-Rogel Center for Chinese Studies. I'd like to welcome you today to our final presentation in the virtual noon lecture series of the Lieberthal-Rogel Center for fall 2020. The series will resume in winter term 2021, and a schedule of presenters will be available in early January. We hope you will join us at that time and that my dog will no longer be barking by then. Today's presentation will be given by Nicholas Howson, Tsiang Chair, Professor of Law at the Michigan Law School. He is a specialist in Chinese law and legal institutions and developing Chinese jurisprudence. He is a former partner of the New York-based international law firm Paul, Weiss, Rifkind, Wharton, and Garrison, where he was a managing partner of that firm's Asia practice based in Beijing. Starting in the late 1970s, he has spent more than a decade as a student, scholar, and practicing lawyer resident in Beijing and Shanghai, and has been active in the Chinese courts and US and international judicial fora as both an advocate and expert witness on Chinese law. Since the late 1990s, he has advised the National People's Congress and PRC ministries on the drafting and amendment of key reform era statutes and administrative regulations, including the 1999 PRC Securities Law, the 2006 PRC Company Law, and the 2020 PRC Securities Law. In case you were wondering, that is the translation for all the dogs who are listening. Today, he will be speaking on the People's Court's 40 years on, appraisal, and argument. As we've done in the past, please enter any questions that you may have for Professor Howson in the Q&A, and I will read them at the end. We are delighted to present Nicholas Howson.
Thank you, Twyla. Thank you, everyone. That's a wonderful introduction with the thematic dog barking. I actually have a cat here in the room that I'm speaking from, but because I have headphones on, the cat is still fine and reclining. Just to explain my setup, you see me at a podium, or you may understand I'm at a podium. That's because before this talk, I set up a situation whereby I'd be speaking into my laptop and then looking sideways at a monitor where my notes were, and I realized that you would spend most of the time with me looking inside one of my ears or the side of my nose. So I've rejiggered this. As I just assured our colleague Ina Schlorf, this is not the way I talk to my family members or lecture the children when necessary. So thank you to the center, of course, and Ina and Twyla for her nice introduction. What I want to do today is something relatively informal. I want to prod a kind of discussion or start a conversation with all of you about the Chinese courts. And obviously I'm going to focus on the Chinese judiciary, one department of the government of the modern People's Republic of China. I'm tempted to call it the judicial branch, but I think that word is already misleading for many of you, and in particular many of you who hear that word in the United States, because it conjures up notions of separation of powers and something like independence, at least independence as distinguished from other branches in our government here. The truth is that the judiciary in the People's Republic of China is something which is really, in my mind, sort of a line bureaucracy inside the Chinese party state, and something which is really closely tied to both the central legislature, the National People's Congress, and then local courts at local levels are tied very closely to the what passed for the local legislatures, the local people's congresses. So when I'm talking about the judicial branch or the judicial department, I want you to divorce it from any notion you have of an independent branch. And what I'd like to do in this conversation today is to encourage you all to think about this particular department on its own terms. And that means I want you to think about the Chinese judiciary in modern China in relation certainly to Chinese history and governance institutions which have existed for, in some cases, thousands of years. Most importantly, and perhaps obviously, I don't want you to compare the Chinese judiciary as it exists now to some kind of idealized or even realistic version of what you think we have in the United States or Canada or Western Europe or South America. This is something which is different in very significant ways, and it would be helpful if we didn't bring to the analysis lots of purportedly understood information about other institutions in under other regimes. And I guess most importantly, I want you to understand the Chinese People's Court system, or this department of the government, as something which is anything but static. We've seen extraordinary changes over the last 40 years, certainly in the last 25 to 30 years. And it's something which really does change every day, every month, every year. And that's something which I hope to indicate to you in my remarks. Now, a word about my what qualifications I have to be speaking to you about the Chinese judiciary. Well, I'm not, it turns out, really a student of the Chinese courts or the judicial branch, so-called, at least directly. That's not the focus of my academic work, but I am assuredly a student of the Chinese legal system, and I spend a great deal of my time in my research and my writing, reading and analyzing the major product of these institutions, which of course are case judgments or case opinions. But in addition, and I think as referred to by Twyla in her kind introduction, I'm also a bit of a rarity among academic specialists of the Chinese legal system, both abroad and inside China, in that I've actually worked in Chinese courts. I've appeared in Chinese courts as a party representative, meaning as an advocate, as a lawyer, and also as an expert witness. And I've appeared in courts even at the basic level, certainly at the intermediate People's Court level, and most recently in a proceeding before the higher People's Court, in this case in Beijing. And in fact, that case is now on appeal to the Supreme People's Court in Beijing. So I may have a chance finally in my career to give evidence or to advocate before the Supreme People's Court there. And lastly, I want to declare that, I have very strong friendships and personal relationships with judicial officials in the People's Republic of China at various levels, certainly the intermediate People's Court levels and the higher People's Court levels, but even the Supreme People's Court. And these are officials or bureaucrats who in most cases are extremely interested in reform programs and have been over 20 or 30 years. So I want to use some of the learning that they've given me to describe a little bit about what's up. The other thing to say, of course, and this really goes to my personal biases, is that I've watched these developments over more than 30 years. And from a time when the People's Courts were really a nullity. If they existed, they did very little. There were no lawyers to appear before them. There was very little substantive law. There was absolutely no procedural law. And courts in those days, or at least when I started interacting with them in China, were effectively just another expression of the coercive power of the state or the party state, but brought onto the heads of the governed, in the mission of social control. So many of you will think that's criminal law. It's criminal law plus, but it's this idea that that's what the courts were doing. They were sort of an adjunct to the police. And this allows me to tell one embarrassing anecdote. Those of you who know me know that my days are filled with the making of excruciating faux pas. Well, here's one faux pas that I made in the early 90s in London when China had sent out the first delegation, the first human rights delegation from the PRC after the Cultural Revolution. And this I think, was in 1990 or 1991. And it was led by a wonderful scholar and official, Wang Jiafu, who was then head of the Legal Research Institute at the Chinese Academy of Social Sciences. We were having dinner in London, and someone in the group raised the fact that Deng Xiaoping had just announced at that moment that there were going to be huge cuts to the military. They were going to retire a lot of PLA deadwood to modernize and to shrink the PLA, which had grown, of course, incredibly after the Cultural Revolution and into the 80s and then even in the early 90s. So when that came up, and I think Wang Jiafu said, yep, they're going to retire a lot of military officials, I responded immediately, fa guan jiu duo le ma, meaning, that means there'll be even more judges. The problem with it was a faux pas because obviously I was revealing something which I'm not trying to communicate to you in my crazy way, which was that most judges, most of the people who populated the courts then were either reassigned police officers or much more often in those days, military officers. So these should, the identity of these people, these personnel should really make you consider exactly what the courts were in those early days. So as I say in the abstract that I offered, and I think was connected to the advertisement for this talk, one of the things I want to do is not defend the Chinese courts. That would be difficult in some cases. But I want to push back a little bit on some of the, I could call them memes. They're kind of cartoonish memes that we read or think we understand about the Chinese court system. And here I'm really talking about memes that you see in the popular press, but also among the conoscenti, the people who make a life analyzing and evaluating the Chinese legal system. Now, some of these memes should be familiar to you, and I'll just list some of them now. One is that, of course, the courts don't have the technical competence to handle really complex problems. Another is part of the music that I just retailed here, that really the courts are just another bureaucratic agency in the PRC party state and are tightly controlled by the party state with no ability to demonstrate anything like functional autonomy with respect to the law or any decisions they make. Going further in the direction of what I think are misleading memes, there's this idea, as I say in the abstract, that the courts are really the cat's paw of an overwhelming system of social control, whereby the courts are just another agency that brings punitive law or coercive legal norms on the heads of the governed. You even will read sometimes in the discourse, and this is more in the popular press, that the people's courts in China are something equivalent to Hitler's courts under the fascist German regime after the middle 1930s. The idea is that courts are just playthings of overwhelming political and prosecutorial power. And then there's another meme which I wish I had more time to sort out. There's this idea that whatever the courts are, people in China accept them as such, and either they accept them or they don't accept them, and they turn into dissidents. Now, there's another set of presumptions, but it's more about presumptions of modes of analysis that I want to point to before I get into the main part of my remarks. And it's the way people like me, sometimes legal scholars, but also our sisters and brothers in political science and sociology, look at the court system in China and analyze its effectiveness or its whether or not they're subject to political control, et cetera, et cetera. And there are a couple of ways which I want to identify now in which I think that those analyses by extremely well-trained individuals, colleagues, friends, goes a little bit off the track. One way in which analysts go off the track now or off the tracks now is by investing the rhetoric and sometimes the law and regulation that comes out of the center in China. Sometimes it's the Supreme People's Court, sometimes it's party pronouncements from Politburo or party agencies, sometimes it's the State Council or the NPC. But there's a lot of rhetoric and a lot of regulation which is articulated or issued, which I would submit has very little to do with what actually happens in the day-to-day operations of the courts at all levels. And I certainly mean outside of Beijing. So I guess my complaint is that some people take too seriously the formal pronouncements about what the judicial system is. Another, not a problem, but a difficulty I have in modes of analysis. I have a cat that might be, no, okay. Another problem I have in modes of analysis is this really strong emphasis on the people who are judges as cadres, as administrators, cadres in the system, and looking for either the way they are educated or trained, or indeed how they are incentivized to make advancement within the system, whether it's the judicial system or the nomenclatura system, the party appointment system, which exists always in parallel. And I think a lot of scholars make the mistake, I would submit, of tying those incentives or those educational attainments or those training attainments with the ability of judges to do their jobs, whatever you think their jobs are, and of course their relationship to an autonomous legal state. Another problem that I see often is, this is mostly with our political scientist friends, is the sort of data-driven inquiries which look at scads of cases and say, look, in these cases, so many people won, so many people lost, and they don't account in those data-driven accounts for the underlying substantive law or procedural frameworks, or indeed the merits of a certain legal claim. So for instance, and I think I'll probably return to this example in a moment, you might see a study that says, look, here's a whole kind of litigation that involves state actors on one side and non-state actors on the other. And I can identify that the state affiliated actor gets a favorable ruling in so many situations. The implication there, without looking further into the cases, is that somehow the state affiliated actor is privileged, or somehow there's bias in favor of whatever their claims are. And I want to, as I say, interrogate that in a minute. I'm going to do that in 1 second. So the only thing I want to say, or the thing I want you to come away from this particular discussion with today, is it is incumbent upon all of us, if we want to make a fair evaluation as to what the Chinese courts are actually doing, and this is both in the civil and the criminal sphere, is that we have to read the opinions. We have to try to understand what they're doing, not just what they think they might do or they should do or they're incentivized to do. Why is this important? Well, it should be kind of obvious, because inside these opinions, which are now incredibly available or widely available, inside these opinions lies the basis for a really complex evaluation of what courts do in a complex way. So I want to give you an example. It's related to the example I just surfaced a moment ago. You might do, for instance, a study of all contract cases in China or in a given province between, say, private entrepreneurs and state-owned enterprises, whether or not they are corporatized. And you might kick out some data from that study that says in 70% of the cases, the ruling goes in favor of the state-owned enterprise and against the non-state affiliated entity, say the private entrepreneur. And you could use that data to write up, a really good paper to say, well, the implications of this are that somehow, local state firms have sway with local governments and thus local judicial institutions, or there's some kind of bias in favor of them and against non-state affiliated actors. But there are all kinds of questions that for a lawyer come into view even when you consider that data. And so one of the first questions I would ask as a lawyer is, what does winning the case mean, right? What does it mean to say that a certain party won? Because as some of you know, legal cases can be very complex. There can be different parts, different claims, and it takes some investigation to determine whether or not the win was total, whether or not the judgment went in favor of one party or the other, and whether we're really trying to pull apart what the actual judgment is, which, as I said, can have several heads, several directions. Much more importantly is, unless you read the opinions, you have no idea who had the best legal claims in the litigation that you're assigning, one side winning or one side losing. So for instance, the example I just gave you, what if a private entrepreneur has just decided to breach a contract with, on the other side of the contract, a state-owned enterprise, something which we think of as a privileged actor in this circumstance. It's only when you read the opinion that you understand that the private entrepreneur never should have won the case, never should have had a positive judgment in its favor. But you don't understand that unless you push through to the opinion. And then finally, and I guess this is something that perhaps lawyers or legal analysts will love the most, only when you investigate the opinion, or the opinions as in most cases, can you understand whether or not the courts actually just did a thumbs up, thumbs down number, which is almost a complete rarity now, or instead reasoned to a certain result. Was the reasoning principled? Did they use the law? Did they use doctrine? Did they think up their own doctrine? Did they refer to accepted doctrine? In short, were they doing their jobs? Were they acting as judges in an informed, principled, and complex manner? And that's a really important way, in my mind at least, to evaluate what judges are doing in China now, and whether or not they should be evaluated as doing a good job or a better job, as opposed to something else that we might say. I guess, maybe I'll have time at the end of my remarks. It's my idea that you need to evaluate the judiciary in China along three separate lines: at least technical competence, something like bureaucratic autonomy, or just think autonomy, and then political independence. And I don't think you can do that in a fair way unless you actually delve into the opinions. So let me give you an even more complex example, and it comes from two cases that I've recently read and I will write upon. Some of you may or may not know that securities fraud actions are allowed in China after 2003. What's securities fraud? Well, it's an issuer sells you shares, a company sells you shares in a company and lies to you and says, oh, we've gone great guns the last 3 years, everything's great, here are our financial statements, look at how well we've done, and in fact the financial statements are fake or are fraudulent. After 2003, a Supreme People's Court regulation came into force allowing private litigants, this isn't the government, but this is private claims on that kind of fraud, but gave that benefit or that private claim with a condition. And the condition, of course, not of course, but the condition, which I'm going to tell you, is that you cannot make that private claim, you cannot make that lawsuit until a government department, in this case it's the China Securities Regulatory Commission, the equivalent of our SEC in the United States, until they have made a decision that there is fraud and that there is legal culpability. And what that means essentially is that private litigation, private enforcement of these claims is relegated only to enforcement claims for damages. I suffered this much, here's my money damages, not whether or not the company that committed the fraud was guilty of the fraud. I may have to let a cat out. Yeah, I'm gonna let a cat out, 1 second. Twyla had dogs, I have cats, or I have cat. Okay, so if that's the requirement, I will highlight to you two recent cases. One is a case in Chongqing where a rather, you might say, courageous judge said, you know what, there's that precondition that you've got to get the government to sign off on a penalty before you sue for private damages. I don't like that. It really stifles private enforcement and these great actions in favor of justice. So I'm not even going to pay attention to that, and I'm going to allow a case to go forward on securities fraud. There's another case, another opinion which I've recently read, which says just the opposite. When faced with a really creative lawyer's claim, which goes like this: well, China, that recently you've liberalized the case establishment procedures. Case establishment procedures were used for years in China to block a lot of cases coming to the courts. We know you liberalized that, and therefore that means that this precondition that we see in the specific world of securities fraud enforcement is a dead letter, and therefore we don't have to worry about it, and therefore we'd like to bring our claim for fraud directly to the courts. A court in Guangzhou said, doesn't work that way. Good try, but in fact that precondition still exists because it's in the law, and sorry, you have to get a CSRC penalty decision before you can actually bring a claim to court. So the question is, how do you analyze two cases like that? Now, it depends upon what your priors are, right? You might be, like me, someone who is wholly in favor of private enforcement. You think it's not only good for regulation of, in this case, the capital markets, but you also think that it's something which will provide oxygen to the whole legal system. The more private claimants you have coming into the courts, the better the courts will be, the more you'll have rule of law, the more you'll have accountability for all the, the guerrillas who are in charge. It's a really good thing. You might think that's great, and you might say, "Ooh, look at what that judge in Chongqing did. That's fantastic." They kind of cocked their nose at the norms in national law, or in this case, regulation, and said, "We're going to go ahead, notwithstanding. That's a courageous and highly autonomous move." You might be someone who says, "Well, there is a legal system, and I really would prefer that my judges acted in a principled way, and in a way that didn't really go off the reservation, right, with respect to what is available in law or other stipulated norms. And in fact, or contrary to the first case in Chongqing, acts in a way that's not only responsible, but really competent, right? It's quite a thing for a judge to look at a creative claim like the one that I just invoked and say, nice try, but you're not going through. Now, of course, to people like me who are, foursquare in support of private enforcement, I don't like the result, but boy, as a legal analyst, I might like the result much better than the courageous, autonomous Chongqing judge who has looked through the law and gone walkies around the bend. So this is to indicate to you why I think, one of the reasons I think we have to look into the cases, we have to look into the opinions before we summon our own courage as analysts or just casual observers to understand what appraisal we have of the courts. And I have to say this, that one of the things that's unique about the Chinese court system is, or procedure, is that almost every case has at least 2 hearings. Now, as I've made clear to some of our colleagues, that is not an initial trial and then an appeal. Why? Because both of those procedures are what we say in the law are de novo, meaning they're entirely new. So contrary to many legal systems which try to identify the facts and then the applicable law in a first proceeding and then appeal only on the law, in China, that's not the way it works. Everyone basically gets at least 2 bites at the apple, right? So you first make your claim. So that means that there are, in most cases, not just one opinion to wade through and to understand the facts, how they're determined in the law, etc., but 2. And very often there's a real difference between what 2 levels of the court system do. So let me just retail a couple of the sort of common attacks, really technical attacks that are brought against the people's courts, and then I'll jump into some exposition on what's really happening in the courts. So as I've said before, one, and these are just sort of among many of the attacks that you might have heard, one is, of course, that the courts at local levels, and local, I of course mean provincial or directly administered municipality, are just simply not independent of the local government. And there's a direct line that you need to draw between the courts and the local people's congresses, as we draw a direct line between the Supreme People's Court and the National People's Congress in Beijing. Perhaps more compellingly, we don't think that the courts have a lot of independence from the party and party institutions. And here, you need to understand, as I'll talk about hopefully in a minute, that there are courts are infiltrated or matched by very, very serious party institutions. And, under the so-called dual leadership scheme that we all know and love in China, you have to understand that a court not only is subject to some connection to its co-equal People's Congress, but also there are party institutions which tie directly into the courts. And then, of course, local courts have to pay attention to what superior courts in the same higher people's court system want them to do. So it's not an easy job to be independent in whatever terms in the courts, and this is one of the attacks that we render against the courts. Also, and relatedly, the procurator system, this is basically the prosecutor's office in China, has not only formal authority, but obviously informal authority over what the courts do. And this leads to a strange kind of anomaly in China, whereby you have the prosecutor coming into a court where the prosecutor is actually a bureaucratically superior institution to the court that's hearing the showing made by the prosecutor. So that's another thing that we identify as lack of independence. Perhaps most critically, everyone recognizes that there's a funding problem in China for courts and their ability to demonstrate their independence. And that's because local courts are funded by local governments, okay? And that has to make you consider the difficulty for local courts to act against other aspects of the local government when they are in court before them, right? So this is one of the real bugbears that China has faced for years and years. Relatedly, and I'm just going to give you sort of a list, there's the idea, or we know this for sure, that Chinese judges don't hear cases alone. They always work in Heiting, which are either three judges, a three-judge panel, or two judges, and sometimes a lay assessor, which is supposed to be sort of a proxy for a kind of jury. And so that is always seen to be problematic. Another thing that's well known in China is that the judges who hear cases don't necessarily write the opinions that I was just trying to validate as something worthy of exploration. In addition, we know that pursuant to internal rules in most of the court systems, judges have to get approvals for almost all of their decisions, and certainly decisions which have a special impact. Also, litigants in China regularly complain about the very high fees required by the courts. That should make sense to you if you understand that the courts are basically on their own in terms of financing their operations. Also, that the courts and court proceedings are not only perhaps biased or twisted, but are also very slow and inefficient. People complain regularly about lack of transparency, about what the courts are doing and what their judgments are. There are complaints about the training, or there have been complaints historically about the training of judges and people's court personnel, the administrative personnel, and this idea, this is an older idea, but it still lives on, that in fact the exams that judicial officers took were easier to pass than the exams that lawyers took, and therefore you have a lot of lawyers in China who say, my God, I've got to plead my case in front of someone who's a sort of lesser species of lawyer than I am. And then we get into, the prevalence of ex parte contacts by Chinese judges with parties outside of the courtroom. And of course, the mischief that we recognize is endemic in China, which is corruption. And then finally, there's sort of an institutional complaint about the courts, which is that courts aren't like courts you may think about. They don't have any authority or ability in the Chinese circumstance to sort out conflicts of law. And that may seem very strange to some of you who say, well, what else do you go to a court for, right? You need to know which law governs, which law has priority. Well, the Chinese courts are not allowed to do that. That is actually something which is in the hands of the legislature, the National People's Congress, and in fact, its standing committee. And that works both horizontally when you have two equivalent norms that are in conflict, and certainly vertically, where you have lower norms that are in conflict with either the laws or in some cases the Constitution. So people sort of throw up their hands and say, boy, what's the court system about? What's it for? It's a complaint that goes that way. Okay, I see that I have just a few minutes, so let me try and pick out some of the best stuff that I have in my abundant notes. First, just by way of introduction, to help you understand what this thing is, the court system has jurisdiction formally over at least three worlds of cases. Criminal law, of course, civil law, and here when I say civil law, I really mean everything that isn't a criminal law problem, and then finally administrative law. And administrative law in the Chinese circumstance is the ability of the courts, pursuant to a late 80s authorizing statute, to declare that a government official is acting effectively ultra vires outside of the power that is conferred upon them by either law or regulation. And that comes to us under the administrative litigation law. As I said a moment ago, courts do not have the power to sort out conflicts of law either horizontally or vertically. There's one small exception to this idea that the NPC is entirely in charge of what we would call interpretation of the law, and that is a delegation of power to the courts, to the Supreme People's Court, to issue quote unquote interpretations of statute. And therefore, you see a number of interpretations over the years of Chinese statute, which is promulgated by the National People's Congress in Beijing, but these abstract interpretations as to what the various provisions of the law might mean. What's important for you to recognize as non-legal specialists is that this happens outside of cases and controversies. It's an abstract exercise whereby one part of the bureaucracy provides a gloss on statute, but not necessarily a gloss, absolutely not a gloss that comes with respect to a live case. So, when I look at the current state of the courts in China, and I look back at the days when I was making faux pas in front of Wang Jiafu, and even before that, boy, the courts have grown in China in the last 30 or 40 years. I'm looking at the statistics now on my notes from the 2019 Supreme People's Court work report, which is delivered to the National People's Congress each year. And I won't have time to sort of introduce doubt as to what some of these statistics mean, but they are impressive and interesting nonetheless. In 2019, there were 16.17 million civil and commercial cases concluded in the People's Republic of China, including 9.3 million cases which were concluded or got to judgment on the first instance proceeding, and then 4.5 million, 9.3 million was civil cases and 4.5 million was commercial cases. And that means that there are roughly 2.25 million civil and commercial cases that were resolved at the second hearing, at the, I don't want to say appeal, but at the second stage of these procedures. With respect to criminal cases, the report reports that there are 1.97 million criminal cases concluded, 1.3 million which got to a judgment or a verdict in the first instance, and then about 680,000 criminal cases that were concluded or affirmed or changed a judgment at the second level. And here it's probably better to think of those as appeals. And the reports are from this report that 1.6 million were convicted under this part of the judicial system. With respect to administrative litigation, which, as I said one moment ago, ties into the ability of the courts now in China to declare government action ultra vires, at least not in accordance with what the law provides. There were almost 700,000 administrative litigation cases concluded, and 284,000 of those were first instance administrative litigation cases, and that means 400,000 plus administrative litigation cases were concluded on appeal. With respect to the number of judges, there are now judges, and this is not judicial personnel in the system, but judges. There were over 126,000 judges actively working, with the average number of cases handled per judge reaching a whopping 228, at least in 2019. Now, I can see that my time is almost up, and there's just a couple of things that I would love to communicate before I turn into a pumpkin. And I guess what to do. The first thing to tell you is that the court system in China is organized with a Supreme People's Court in Beijing, which is, I think, of the apex of the judicial bureaucracy. The Supreme People's Court in Beijing is not really, I mean, it is a Supreme Court, but it's not a Supreme Court in terms of adjudication. Yes, they do hear some cases, very rarely, Yes, they do issue opinions. Yes, they do issue interpretations. Yes, they do now issue so-called model cases, which they hope lower courts will follow. But the real action in terms of the judiciary inside China occurs inside what we call the higher people's court system. So these are systems attached to either provinces or directly administered municipalities. And the reason I would want to focus on this if I had more time is that they are in many ways largely independent, or they take up that tension that many of the auditors today know exists between the central government and local governments throughout Chinese history, but even in the current circumstance of the post-1949 People's Republic of China. And the reason I want to emphasize that is because if you're looking to evaluate the performance of the judiciary writ large in China, you really have to focus on what happens inside the higher people's court systems. I'm gonna just turn off I shouldn't do that. Yeah, shouldn't do that. Okay, I'm just gonna say one quick thing. Sorry, everyone, you never get enough time in these presentations. There are two institutions that many of you may know about, which work inside the courts. One is the so-called adjudication committee, and one is the political legal committee, which is attached to every level of a higher people's court system, all the way down from the higher people's court to the intermediate people's court down to the basic level courts. There's a real question for analysts as to how much interference is coming from either the adjudication committee or the legal political committee. There's a lot of data now on what the adjudication committee does with respect to specific cases. And I think the picture generally recently is quite benign. And I can perhaps in the Q&A, I can talk a little bit about what the adjudication committee does. The bigger problem or the bigger issue is what the so-called political legal committee does inside each court system. The political legal committee is a committee made up not only of party officials, but also officials who are part of the state security, bureaucracy, other parts of the state. And they will get together to articulate policy, sometimes shape individual decisions in cases, but certainly lay down something which looks like a party line. And the only thing I want to say about the political legal committee is that it's certainly described as a great ogre in any telling of the Chinese judicial system in modern China. And certainly that's true and has been true, in decades past, such that when we had Yenda, right, strike hard campaigns, it's clear that there were directions coming from the political legal committee or their equivalent. Same thing with the actions taken against Falun Gong, now several decades ago. And of course, the anti-corruption campaign that we're, I guess, still living through right now. But I would beg you to understand the political legal committee is also an institution which occasionally acts rather benignly. And I'll just give you one example before I conclude. And it's this. During the 2008 financial crisis, the political legal committees inside the court system said, look, whatever you do, don't give free rein to creditors' rights and throw many of our manufacturing companies into bankruptcy, right? You've got to let them survive and not create all those unemployed workers. Now that was a command that came directly from the political legal committee, but it also twisted the application of formal law. And I think we might all agree that that's kind of a good thing, right, in a crisis, and we would expect that some of the same kinds of commands are coming down in the present circumstance. Unless you think that's very exotic, we did the same thing here with General Motors and its bankruptcy in terms of twisting the law completely as the White House saw the rule of absolute priority should be applied. So I'll leave you with that thought. Just one last thing, maybe we talk about in the Q&A. The real question for me is whether or not the particular advancements that at least I perceive in the civil and commercial sphere will have a strong effect in the coercive social control sphere, which of course is the way the courts act in the criminal law circumstance. So I'm going to shut up. I went way over time. Sorry, Ina, if you're out there. Sorry, Twyla. I should, yeah, our Lingdal.
All good, Nico. So we have a series of questions. Thank you very much for the talk. And I am going to start with a question from Shuyu Long, who asks, where do you see the Chinese legal system going in the next 40 years? And so when you get your crystal ball, and how do we view Chinese Communist Party as using the legal system for fanfu, it's very small on my screen, sorry.
So this is the first question, obviously triggers a long discussion in my mind. Question is, can I articulate anything useful for you? This is speaking personally, given my experience in the Chinese legal system, I have a lot of faith now that, what I alluded to at the end of my talk, that many of the advances, or I call them advances, or I value them as advances, that we've seen in the civil sphere, and that is in the context of the legal system having to deal with markets and market actors and property rights and all that stuff which leads to kind of independent, non-government tied claims and justice interests. The changes that those phenomena have triggered in the civil legal system, I believe, will increasingly have implications in the much more problematic sector of what I was calling social control, or the criminal sector. Now, is that going to happen in the short term? Maybe, likely not. As I said in my remarks, I tend to look at these developments over a really long span of time, and I'm extremely impressed as to what's happened in one sector. The question is, will this particular regime be able to accommodate those changes without underlying political reform? And you know, if you look at some of these things, you see the exact same trajectory in Taiwan, but that the final step, the social control, the constitutionalism piece, didn't happen until Taiwan stopped being a military government and started being a democracy. And then the second question was, can you just say it again? It was about the party rule, or
yeah, so
Fan Fubai, right?
Yeah.
Yeah. So I think my vision is that this is what's happened in Fan Fubai is good, not for the Chinese legal system. It's good for carting off corrupt cadres. Of course, though, that carting off has taken away some of my dear friends who I think are innocent. And so I worry about, as a political campaign, it being deeply unfair and pernicious. My real problem with Fan Fubai is this conflation of the party discipline system and what I think of as state law. And you see this in terms of the National Supervision Commission, the idea, just a couple of years ago, that first you subject someone to what everyone calls shuanggui. Shuanggui is just the first moment of the party discipline procedure. You get a result there, and then you cooked up a lot of evidence, and then you transfer the person, maybe Bo Xilai, into what is a state law proceeding, which is a criminal law proceeding. And to me, that's just terrible. Why? Because you don't provide any guarantees, any procedural guarantees or rights guarantees for people in the party disciplinary context that you then get to use when you bring a criminal prosecution. So to me, I'm kind of outraged by this one implication of the Fan Fubai effort. And I hope that the conflation I talked about that we now see in the National Supervision Commission and the conflation of these two systems does not become a permanent feature of governance in China, whatever regime it's under.
Thank you. Second and third questions I'm going to combine. So the one is, what are some reliable sources for legal opinions? And the other one, both of them I think could be possibly short answers. Can you explain more about the specifics of the two separate de novo hearings?
Okay. The first one is, I didn't get a chance to say it because I didn't get a chance to say a lot. There is now, since 2013, this monster database of over 100 million case opinions called Tsiang Wenshuwang. And it's extraordinary, right? I mean, whatever complaints we had about transparency with respect to opinions in China are effectively defeated. Now, there are problems in terms of accessing. There are doubts as to whether all opinions ever written in China, particularly about Tibetans or Uyghurs being carted off, or any other number of human rights nightmares, whether or not they're also posted. But boy, in even the short history of what the Chinese courts are doing, this is an extraordinary step, and it's obviously a great benefit to people like me, but also for the governed in China, right? That you can now access the internet and see opinions if you're interested, and if you have the competence to understand what's going on. So I think that's pretty extraordinary, and it takes me back to my days when even when cases started to go online, they only went online by the provincial people's court systems, and it was really hard to look at them, even though I had the assurance that they were largely accurate. Second question, Twyla, again, I'm sorry, I keep getting lost on the second question.
Explain more about the specifics of the two different de novo hearings.
Very simple. Everyone gets 2 bites at the apple on everything, on facts and law. So you'll traditionally have a second opinion which reevaluates all the facts. All the facts are submitted. There may be new facts submitted. And then you have a new application of sometimes new law, regardless of what happened in the lower court. And that is different from the way certainly common law countries work, which is to stabilize the facts, apply the law in a certain way, and the only thing you appeal is the application of the law to those solid facts.
Great. Okay, so got a couple longer ones. So the question is, how can we adjudicate the professionalism of and this is from Mary Gallagher, professionalism of the courts and the legal profession without considering the laws themselves? And if Chinese laws are increasingly illiberal or repressive, such as the national security law for Hong Kong, we might observe courts and lawyers abiding by that law, but would that make the courts and the entire profession more law-like, or China more a rule of law state?
Yeah, no, exactly. And this is obviously something we think about a great deal. And I tried to go to some effort, I didn't have enough time, to really separate out the piece of the Chinese law and legal institutions, which is in the non-criminal or the non-social control sector. So just as you will have substantive law in the criminal law, which is, as Mary suggests, could be increasingly oppressive, could be increasingly devoid of what we think of as critical, either substantive or procedural protections. Just as you have that, then if the courts are going to act responsibly, right, they probably act responsibly in accordance with those oppressive norms. And that's why it's important for me to separate out, and not excuse, but to separate out these two kinds of activities. But Mary's exactly right. You know, strictly speaking, if you have courts that are complying with the law, whatever the substantive law may be, that's them acting in accordance with the law. And, you know, someone, I don't think anyone on this call might celebrate that, but that's not, in my mind, what's going on in the non-social control, non-criminal sector.
So there are many, many more questions. I'm going to ask just one more because we are very close to our time. And this is from a Chinese lawyer. So Mr. Will Wong asks you, he is a Chinese lawyer. He's a postdoctoral fellow at Trieste University and got his PhD here. And he is curious about your thoughts about the case registration procedure and what you think about this legal reform. So this is a recent change, apparently. And do you think that the case registration procedure will improve access to justice?
Yeah, I mean, I actually referred to it in my remarks, right? That's behind the case in Guangzhou, where you had some very smart lawyers saying, with that reform, the procedural precondition on the securities fraud lawsuits goes away. Yes, I think there's no doubt that the reformation of the so-called Li'an system will and has already opened up the courts to much more significant private claims, it's also acting as a defense against the courts, which are really, looking for any excuse in many situations to not give case acceptance, case registration. So it can only be a good thing. The question, of course, is what about all the other adjunct mechanisms that we might like to see? And our lawyer questioner would certainly agree with this. What about class actions or something which is closer to a class action? What about lawyers' contingency fees that help private claims be financed? What about greater attention to procedural rights once you get your case accepted? What about some doing away with some informal blocks, which we know are rendered internally, which forbid certain kinds of cases coming to the courts, notwithstanding an overt norm that says now there's no case registration block. So lots to think about there.
Just a request as well, if you can provide links to any of the cases or to the database that you suggested.
Yeah. How do I do that, Ina? I think it's the big database is wenshu.something.cn. I'll find it, but I'll send it to Ina, and then Ina can.
Great. Okay, so let's go for one more. This is hopefully an easier one. Can you explain how courts are funded? You said something about them charging high fees, and also how judges get promoted.
Mm-hmm. Yeah, they are funded basically by their co-equal local government level. And as I said in my remarks, that's very problematic, right? Especially when you have litigants who are tied to the local government before the same courts. At the same time, for years, there have been complaints from private litigants that the fees charged by the courts made private actions prohibitive. Now, the separate question of advancement is a very complicated one, and it's changed radically over the last 30 years. Suffice it to say that 20 years ago, judges advanced along two lines. One was their advancement inside the nomenclatura system, but then even as judges, what you saw was the more senior judges advancing, regardless of their competence or the merits, or in fact their legal training. That has been ameliorated, at least in the last decade, not the party advancement side, but the idea of promoting judges based upon their merits and not simply seniority. Now, you still see a lot of badly written opinions produced by senior actors in different judicial bureaucracies. And in my mind, that's a hangover from the fact that those people are still there, even though they're senior, but they're incompetent. Whereas you see some really good opinions written by very low-level judges in basic people's courts.
So, Nico, cool. I figured out how to type into the chat so that everybody can read the link. Can you just tell me what it is?
I think it's Wenshu, WEN.SHU, and I probably have it.
You can, if you can open the participants at the bottom, you have the opportunity of chatting to all.
Yeah, I'm just kind of trying to find it.
Attendees.
No.
You have to click that participants arrow.
Yeah, I'm not finding it here. I have it. Oh. I have it somewhere. Hold on. If you guys can hold on, I'm trying to get it. Where are we? So I'm not finding it. I thought I had it here. Yeah, I'm not finding it. I'm sorry. I'm going to go back to the. I can't find it on my other screen, but it's something like WENSHU, maybe .gov/CN, but I'm just not sure. It's 裁判文书网. So if you put it in characters.
Sorry, what's the last character? I can't hear.
文书网.
Wang. Okay.
裁判 judgment.
Yeah.
中文的文书一本书.
There, I think I got it.
Are we done?
Yep. So
Okay.
Thank you, everyone. And I hope that we will see you all in January. And we will be sending out a listing either later this year or early January about our schedule for the winter semester. Hope you all have a happy holiday season and see you soon. Thank you.
Thank you.